Good evening. I hope everybody had a wonderful Super Bowl party. The people that I was with were very disappointed that the California team lost and the other team won. I don't even know who the teams were. Don't really care. It was just talking and eating and drinking as far as I was concerned. Anyway, dumb people have been suggesting that Elonis v. United States are going to exonerate Eric Brandt. And, well, let me just start off by saying that Elonis was decided on 2015, June 1st, 2015 to be exact. And the case that I chose specifically was after that date. And it's not Elonis really isn't a major decision. But I chose a recent case in the appropriate circuit for a reason. And that was to try to interdict some of the bullshit trying to make me further elaborate because people half-ass understand or think they understand cases or have heard of cases or something, and then I have, and they're just like, Elonis says that he's going to be free. And then I have to go and make a 20-minute video explaining why they're fucking retarded. And no one can just accept that, well, I've actually read it and understand it. And I've given you a good case that's on point. So we will deal with Elonis. What was the argument in Elonis? The argument in Elonis was very simple. What is the intent requirement? That's what they're arguing about. It's the intent requirement. The government said, and the courts agreed with the government up to the Supreme Court, that all that the government has to do is prove that the speaker knew the words. They had to know the words that they were saying and intend to say those words. They didn't have to intend to say a threat. They just had to know what they were saying and intend to say it. And Elonis said, well, there should be some intent to violate the law. I mean, and he thought that the jury instructions should state that the government had to prove that he intended to communicate a true threat, that he intended to communicate a threat, essentially, that his intention was not just to say the words, to know what the words meant and to say them, but to intend to communicate a threat. That's what Elonis is all about. What is the standard? And the standard was, at the end of the day, the government said, or the Supreme Court said, that you had to basically know what you're saying. Let's see, somewhere up in here. It turns on whether or not the defendant knew the character of what was said, not simply its context and content. That's the most succinct way I can think of stating it. So the government agreed with Elonis. They agreed that the government had to prove that Elonis intended to communicate a threat. So after this, I'm sure they found Elonis, innocent, right? No, they didn't. They remanded it for further proceedings consistent with this opinion. So they remanded it back to the Court of Appeals for the Third Circuit. They didn't say, Elonis, you're innocent. They said that the jury instruction that the government gave was insufficient. And the Third Circuit Court of Appeals could either determine whether or not that error was harmless or it was somehow prejudicial. Well, what happened? This is United States versus Elonis. You may notice that this is argued after remand on May 2nd of 2016. And you'll never guess what happened after it was remanded to the Third Circuit Court of Appeals. Well, what they found was that the error was harmless, and they upheld Elonis' conviction. So if you think that Elonis is going to free Eric Brandt because the things that Elonis said were worse or not as bad or whatever you're thinking than what Brandt said, you're wrong. Elonis was convicted. The conviction was upheld. You're wrong. You're dumb. You're not an attorney, and you should feel bad about the life choices that you've made. Thanks for watching. Have a great evening.